Welcome, everyone. I'm James Quigley. This is Quigley on Divorce, a behind-the-scenes look. Our topic today is kind of an interesting one. I've invited to have this discussion with me my partner, Shana Vitek, and Jordan Rosenberg. We are all part of the same team here at Beermann, which kind of dovetails into the topic today, which is, as you're seeking an attorney in a divorce, what are the pros and cons of a big firm versus a small firm? And so Shana and I come from, I think, a shared experience of having a small firm. I had my own practice. Shana was my all-star.
Quigley and Associates.
Quigley and Associates.
I was the associate.
Yes, you were. And we kind of had a half associate in Tony, but obviously had that perspective of a small law firm, us kind of struggling to effectively manage our clients, and then moved over to Beermann in 2005. Mm-hmm. And we've now grown the firm to where we have 40 or more lawyers and all the resources that come with it. So Jordan, as an associate on our team, pretty much every case that we have, whether it's a big case, medium case, small case, we all work together as a team.
Absolutely.
And so what are some of the benefits that I think from your perspective as a partner and yours as an associate, what do you see the benefit being to an individual hiring a firm like ours where we have a team approach, regardless of the kind of case, whether it's a huge case, it's sort of an easier case? What do you think?
And so, I mean, you guys know me, so efficiency is huge. And so I think with a larger firm, and they're all grinning, obviously, because I'm anal about how efficient I am, but
we call him the machine.
Right, exactly. But I think that the big firm really accomplishes that goal. And we really make the most of our time. We make the most of our efforts, and we really streamline the process as much as we possibly can because of the resources that we have, and because we're able to delegate projects to other people and have multiple people be working on a project at the same time to quickly accomplish a goal, jump on something at a moment's notice, and to really, use all our resources to make sure that we're getting the best work product out there.
Yeah. And that's interesting, Shana, because when we had our little shop, Quigley and Associates, and while we represented our clients well, that very point that Jordan raised, that being able to be responsive in a moment's notice, there would be times you and I would literally be on trial together all day long. And whatever happened, all those emergencies that came in and the calls and the clients that had questions, we weren't available.
And it's all about communication. So when we have clients who have maybe had a previous lawyer that they weren't satisfied with, the biggest complaint is communication. I called, I didn't hear back for a week. I emailed 5 times, I got nothing back. And so one thing we have is lots of people who know about your case at any given time. You can always get a hold of someone. Usually you can get a hold of one of us, but we also have paralegals who will work on your case. They'll know what's going on. Our assistants who will know what's going on. There'll be sometimes law clerks who will know what's going on. So there's always somebody you can talk to at any time.
So Jordan, when you talk about efficiency, I think there's 2 components to that definition of efficiency, one of which you talked about and Shana touched on, our ability to get things out the door, our ability to be responsive, to be proactive, to get things filed on time, deadlines, all that stuff is a component of efficiency. But there's also the component of economic efficiencies.
Right.
And can you generally explain in terms of economically, if you're hiring, if an individual comes and hires me as their lawyer, because I've been doing this 27 years, I've tried a lot of cases, I put a team together, which would include not only you guys in some cases, but a paralegal, law clerks who do research and writing for us. How does that work economically?
Well, and I think just kind of dovetailing off of Shana's point first is that there's always someone available, and there's a lot of people that know about what's going on in your case. And sometimes that scares people because of the amount of people that are maybe billing on a file. But in terms of the efficiency aspect of that, and again, that's so important for clients to feel secure and represented. But working we spread the work around so that, my hourly rate is obviously lower than these guys because my experience is less. So at James's hourly rate, it may not make sense for him to sit and type a petition and do the research, where I can do that and, James can review it for less time. And so the team approach, although it's scary to have a lot of people maybe work on your case because you think people are billing more, it's really not like that because we're able to spread the work around and delegate to people with certain hourly rates.
And I think at the end of the day, we see in our bills, even if we have a case against a sole practitioner, a smaller firm, they, at the end of the day, may have a similar or even a greater bill than ours because an attorney at a high hourly rate is doing all of the work, and it's paralegal work, it's administrative work, it's work that either we would do at no charge or at a lower hourly rate.
Yeah. And I'll use this opportunity to directly speak to the viewers and the listeners, because anecdotally, that exact point was made in a case that I tried. It was a very complicated custody case, and the trial went for several weeks, and there was a tremendous amount of money incurred by the parties. And in the case, it was our firm, and same thing. We had a partner, an associate. We had a law clerk who was doing a lot of work, which a lot of her time wasn't even billed, but research and writing. And after the case was over, in the case, the husband had substantial wealth. Our client did not. And so we were left with a large bill at the end of the case, and we had to file a fee petition. And so I literally had to testify in support of the fees that we incurred. And the other lawyer was examining and asking, and we had, in that case, and again, this took more than a year. The trial itself spanned over several weeks. And we had probably more than a dozen individuals within our firm who had touched the file, to your point, doing various responsibilities, delegated assignments, and so on and so forth, various hourly rates. And his argument was that he felt we had billed so much because we had used so many people. But in a fee petition, when we are asking for something, the other side has to say what they've paid. So in this case, and I won't divulge the amount of money we incurred or what he paid on his side, but in that case, it was a 2/3, 1/3. So in other words, they had close to 30% more attorney's fees billed and paid for by a sole practitioner.
Well, and think about that. I mean, that makes perfect sense. Right. So like there's, in the divorce process, it's messy to begin with. And there's a lot of, things that have to be done that are sort of monotonous tasks that you have to be done. Everybody does. So for example, a financial affidavit, right? You have to fill out a form that says what your assets are, what everything is. And to have someone billing a paralegal maybe at $150 an hour instead of a sole practitioner or a smaller shop where there's the attorney who's doing all that work at maybe $400 an hour, just that task alone, you're almost seeing a huge
right.
reduction.
And even court, a lot of
right.
New clients will come in and they'll say, James, we want you to be at every single court date. Yep. Well, honestly, the majority of the court dates are scheduling and, getting a new date or giving the judge a quick update. No decisions are going to be made. The parties don't usually go. So Jordan could easily do that at half the cost of James. And so that's what we typically do. Right. And it's very efficient.
And I think in this case in particular, this individual not only billed everything at his hourly rate, but I guarantee you, because he does have a secretary. He didn't have associate attorneys. He didn't have paralegals. I know he's got a staff person. So things are getting done. And I'm at this individual's experience level, I'm confident he wasn't doing those things, but it showed up as his billing. So in other words, I think he's having a secretary or a staff person doing certain things for him. Like you said, drafting a petition, and he's just absorbing their time at his hourly rate. Right. And sending that, which is why, and again, when I say a 2/3, 1/3, it was substantially, the dollars involved in that were significant. One guy, and by the way, he tried the case by himself. He had a co-counsel sit in on a little bit of the time, but his argument too is you had 3 people at trial every day, which was true. It's myself and my partner. We tried the case together, and our law clerk was there. Now, we didn't bill our law clerk's time. She was there to take notes and learn. And this is how we train our lawyers. But The fact of the matter is we needed the 2 lawyers in court. Why? Because a lot of the cost in trying a case is the preparation. Now, if I'm doing everything, if I'm preparing everything, first of all, it would take months for one person to prepare a case properly for trial, which again, small firms struggle with that. And we know this because you don't have the time or the resources to really always adequately get everything ready the way we do in a large firm. So in this case, we delegated the work, and we do this on trials now, where we're going to be trying a case in July. There's probably going to be 10, give or take, witnesses at the trial.
Right.
Now, if I had to do all the preparation, take all the depositions at my hourly rate for all those witnesses, and then try it, number one, for me to be able to retain all of that information at trial sitting there alone, you're going to miss some things. So having a second chair at trial is critical. But by the way, the preparation, the workload is being spread around amongst everybody, and it's all under my direction and supervision. So it's a much more, again, going to your point, it's a much more efficient and actually cost-effective approach for litigants.
Well, how about the case that all 3 of us tried a year and a half ago, where we literally got hired, 3 weeks before trial. Yeah. And it was one of those things where we had the resources available where we can kind of drop everything. And this was our case. And we properly prepared the case for trial. We took depositions. We tried the case, and we won the case being hired on short notice that's been from a case that's been pending for a long time.
And I remember that. You know what the judge said to us? We went in immediately, and we told our client, there's a chance if you hire us now, the judge may not continue the case. We walked in before the judge on an emergency motion to continue the trial. And this judge, we had tried cases before. He knows us well. We appear in all the courtrooms on a regular basis. And the judge looked at this and said, counsel, you've got a big firm. I know you've got the resources to get this ready. I'm not continuing the case.
Yep.
And that was a situation where, had we not had those resources, in that case, again, involved depositions. There were multiple witnesses at trial that we split amongst the 3 of us in terms of, you take a couple witnesses, I take a couple witnesses. And there's a strategy to who does what. That, as a leader of the team, I have to make some of those judgment calls. But I think what happens, and this is what we've found, and why we're kind of having this conversation, is competitors, if you're a small firm, there's always, in this day and age, there's competition in just having clients hire us versus someone else. So what we hear oftentimes is a small practitioner or a small firm is going to say, oh, it's going to cost you a lot if you go there. Or, oh, they're going to have all these people on the case. And really, it's not that you spend more money, because if you combine all of our hourly rates plus law clerks plus paralegals, you get a blended rate. And we talked about the cost, but it's so much more efficient. And I come from a perspective with Shana of being that small firm and not really being able to always manage things and really be fully prepared. So I think it's much more than just how many people are sitting at the table. It is really a broader approach to representing individuals.
Right. And to the point of resources, I think, to me, one of the most valuable things about hiring a big firm like ours is that we have the ability to create the perfect team within our office for your specific case. So we have attorneys who specialize in everything. We have amazing legal researchers, writers, appellate attorneys, business attorneys. We have attorneys who are skilled in collaborative, mediation, child-related matters. So when a case comes in, no matter how complicated it is, we can put together the group of lawyers that are going to be your dream team to work your case to, the best of our ability.
Yeah, that's a great point, because I've been doing this 27 years and I'm not a collaborative lawyer. I'm not a mediator. I believe in a settlement process and trying to settle out of court, but that's just not my skill set. Shana, you're a trained mediator, you're a trained collaborative lawyer. And so when a client comes to see us, we can identify, listen, this is not a case that should go into litigation. In fact, we should try to keep the case out of litigation. So I'm going to intentionally bring you into certain cases and say, I'm going to step back as lead trial lawyer. I'm not going to come in swinging and fighting off the bat. I'm going to say, Shana, get in there and do your thing. Let's try to resolve this out of court. And that is a very valuable resource because a lot of firms don't have that. And it's a one size fits all,
Right.
which divorce
And in that situation, clients feel super protected because most people want to resolve everything through a collaborative process. Nobody wants to go to court, but they also want to know that if we have to go to court, that I will be protected. So you have that, phase one where you're hopefully going to get it done. But if you don't, phase two, you have, the best trial lawyers available ready to protect you.
Yeah. So I think another kind of false narrative that's out there, small firm, big firm, is potential client goes and talks to a small firm or a sole practitioner, and they say, "Oh, if you go to see Quigley, you're not going to get Quigley. Quigley's going to hand you off to Rosenberg or someone else within the office." And that's simply not true, because there are cases, and by the way, we at Beermann have the ability to handle anything. We've got a multi-million-dollar estate that we're going to be trying in July. And we've got a lot of resources, including one of our business lawyers, because there's businesses involved in that. But we can represent working class people, because we may not have to put as many resources on those cases. And Jordan, we do this quite a bit, where even though you're handling a lot of the day-to-day, and you could take a case from start to finish, I'm not out of the picture. We work together on a daily basis.
Right. And that's like the coolest part about it, and the best part about it, I think, is that if there was a scheme, I always relate it to football. And if clients have a question about it, I always say, well, it's kind of like a football team where you're the quarterback, I'm sort of the running back, or like the center, where it's, everybody kind of has their roles, but ultimately it's over, every major decision that's being made there's some oversight. And so you're calling the plays, I'm executing.
Like the kicker, or?
Shana, you're like the wide receiver.
I win the game at the last
I'm
minute.
blocking for you.
No, Jordan, you're not big enough to be the center. So
I'm kind of like the slot receiver.
They're probably more.
So a nice
like
utility guy, whatever. But that's great. Is that I can run the routes, and James sort of calls the plays, or Shana calls the plays. And there's a lot of cases where we kind of work in three-way tandem, where it's truly a hierarchy. And I can go to Shana, and then Shana can go to James on like the really big picture issues. And so to be able to execute a plan, talk every day, have discourse on some difficult issues in the case. I'm running into problems. Hey, you know what? I really think you need to be in court on this one. This is a bigger issue that's, a little bit over my head, or, a little bit different issue.
And also you can get a second and third and fourth opinion if
that's
you want
the greatest,
to.
Right.
Understandably, the decisions in a divorce are huge. They're affecting the rest of your life. So even as much as you may trust me as your lawyer, it may, be a difficult decision for you to wrap your head around. And so I can bring in James, Jordan, or any of the attorneys and present your situation to them and see what they think. Because the more opinions you get, the better you're going to feel about the overall outcome and how good it is for you.
And how often do we go to one another and just say, listen, I have a case, here's the facts.
Right.
I'm not going to tell you what side I'm on, but let me know how you think the case should settle. Or what do you think about this issue and these arguments?
Yeah. I would say candidly, our going from Quigley and Associates to Beermann in 2005 single-handedly made me a better lawyer, just because of what we're talking about. Now, we've been talking about how that benefits the client to have the different minds, but for me as a lawyer, and I've been doing this 27 years, I still will go to partners. We will still have our own internal conversation. Jordan, we're preparing for a major hearing tomorrow. Yep. We just spent an hour and a half today in the conference room, going through and bouncing ideas, making sure we're understanding the same thing, because divorce, sure, sometimes there's no kids, there's no property, both people work, and it's an easy divorce. But when you get outside of those kind of simple cookie cutter type divorces, which are not most of them, and there's some complexities that deal with legal issues or factual issues, having the resources within a firm like ours, 40 different minds, legal minds, that you can go and sit in someone's office, it makes us so much better lawyers, and therefore what we present to the judges, both in what we write and what we argue orally, is such a benefit to the client, because the judges, when they get that finished product where we've thought about it and we've processed it and digested it, the delivery of that is so much better than, and admittedly, even what we were able to do when we were a small firm. So I think there's a lot of advantages. And again, I think there's just a lot of messaging that's out there, because in this day and age, people are competing for business, and they, you read things online, there's these narratives about what a big firm versus a small firm. But I think having that perspective, going from a small firm to a big firm, I wouldn't do it any other way.
Well, every single divorce is different. Like that, every day as a divorce lawyer is a different day for us. No case, no family is the same. And so even, you can talk to 10 of your friends who have been divorced, and they say, well, this happened in my case. Well, unless every single fact is the same, which it never is, your case is different. And so all the more important that you have as much experience and knowledge behind you, so you can try to understand what your options are, likely outcomes, and any possible angles and arguments in your case.
Sure. I mean, I even think of what we have at Beermann is we also have some super talented appellate attorneys. And so in the off chance we would be unsuccessful at trial and might actually have to appeal a decision, because clearly if we weren't successful, the judge must have made a mistake.
Right.
We've got that in-house. We've got the continuity. And that's so helpful too, because when you're writing an appeal, if you go off to a different firm to hire an appellate lawyer, they didn't try the case. They don't know the facts. They haven't lived it. Where we can sit down as having been the trial team and participate with our appellate team in helping them to really understand what happened at the trial level. So it just goes to, I think, what you were saying, Shana, is divorce in general is such an individual process. It is so unique to that person, that family, that you really have to create an individualized team based upon the facts, the needs, the goals, the legal issues involved. And I think that is truly the benefit that we have here at Beermann, is being able to tie that all together and say, here's the team that's best for you, like you said, the dream team. And that really is something where you cannot replicate that really anywhere else, and it's a great value to the clients.
Right. And a team might be, every divorce is different. Some are easy. I mean, there are those uncontested divorces, and Jordan may be, your primary team, and that's okay. I've divorced people in 3 weeks, and I'm their primary team.
Yep.
On a collaborative case, I'm the primary team. So it's not always 10 people on your case.
Right.
It's always different. Every team is different. We may need 10 people, but typically not.
Right. So I think, kind of wrapping everything up, I think it's really, as you're out trying to understand, do I hire this lawyer who's part of a big firm, or do I hire this lawyer? Make sure you understand the nuance of the distinction between being able to have a team concept versus having one or maybe two attorneys or a small firm representing you. Jordan talked about the efficiency, not only in the availability of us as individuals being available to the client, responding to emails, returning telephone calls, having meetings, but also work product, being able to prepare documents on a moment's notice, being able to go into court on a moment's notice. Those are all part of the efficiency that we as a large firm have to offer. But there's also the efficiency of cost, that certain people within our team, under our supervision and direction, are doing tasks that have to be done, but certainly don't have to be done at my hourly rate as an equity partner, but are still very important and need to get done. So understanding that you would have a blended rate, that we are all participants in that team. It's not a handoff and I'm out of the picture, don't ever call me. So I think when you talk about cost, when you talk about resources, any kind of case, individual approach to the case, those are all of the benefits that we have. And candidly, if I thought there was a negative to going from a small firm to a large firm, we wouldn't have come and joined Beermann when we did. So if you ever have questions as to how it works in greater depth, feel free to contact us. We're always available to discuss. I can be reached directly, 312-621-1225. You can always look at our website and look at the profiles and look at the experience of our firm, which has been in existence for 60 years, at www.beermannlaw.com. Thanks for joining us.